Thank you for joining us today for our presentation titled Legally Navigating Workplace Disability and Religious Accommodations. I'm Catherine Brestowitz, and I'm joined today by my esteemed colleague, David Gabor. Over the next 45 minutes, we are going to present you with several real-life scenarios that will help you to better understand some of the common issues that arise with and nuances about workplace accommodations in the interactive process. Much of this is pulled from mistakes that have led to litigation over the last few years. Specifically, we're going to learn about and review the following. We will start off with two different disability-related scenarios. Within each scenario, we will touch upon the various agenda items. This includes an overview of the Americans with Disabilities Act, known as the ADA, a discussion on what a reasonable accommodation actually is or could be. David will then discuss the new Federal Pregnant Workers Fairness Act and how reasonable accommodations and employer responsibilities tie into that new federal law. We will then shift gears slightly and turn our attention to religious accommodations under Title VII. Then we delve into the interactive process with accessible tips for employers. That leads quite naturally into how to properly document the interactive process. The remaining topics should help management to stay in compliance with the law, avoid claims of retaliation and disparate treatment. And if any of you have joined us for webinars in the past, the last item on our agenda may look familiar. David and I like to wrap up our webinars with a top 10 list of take-home messages for our webinar attendees. So, without further ado, David, can you please set the stage for our first scenario and introduce us to our fictitious employee, Agnes?
Thank you, Catherine, and thank you all for joining us today. Please bear with me as I am battling COVID and my voice is not as clear and crisp as it usually is, but let's get through it. So one of the things that Catherine and I wanted to do was to take real cases, real situations that have gone to litigation that we believe were avoidable by just giving an overview, a background on the topics. So the first case we have is Agnes. She's been working at KB Property Development Company for 3 years. She's a full-time employee. She needs to go out on leave for knee surgery. She tells her manager she has to go on leave. Now, most of you on the call today already know exactly how the manager should respond. Unfortunately, we see far too many cases where the response by the manager or someone in leadership is poor. So what KB Property should understand is that Agnes likely is protected under the Family Medical Leave Act. Under the FMLA, she may be entitled to up to 12 weeks of consecutive or intermittent leave. KB Property would have to ensure that she is able to return to that position at the end of her leave. Absent minor exceptions, KB Property Development has to protect the position. There are a couple of exceptions. One is if they can establish that she is in a key position, which is very difficult to do. And the second would be if there's been a bona fide position elimination. In that case, then the company would need to find a substantially similar position for Agnes.
David, I've had several knee surgeries myself, so I have to ask, yeah, what happens if Agnes isn't recovering as quickly as her physicians anticipated that she would, and she ends up needing some extra time before returning to work?
Well, first, I shouldn't joke. I'm sorry about the surgeries. I know we've talked about them in the past. So you might say that was a knee-jerk reaction on my part.
Oh, boy.
Yeah. However, I'm glad that you asked the question because that ties into what has caused problems. Initially, the protection Agnes had was under the Family Medical Leave Act. And the responsibility ends at the end of the 12 weeks. But now we've got protection under the Americans with Disabilities Act. And the question then would be, is she entitled to, let's say, 2 more weeks? You know, if she needed 2 more weeks to get well. Now, there are some protections the employer has. They have a right to know how much more leave she would need. Is she fit for duty at the end of that leave? They can ask for a note from her doctor confirming that she's got a return date. There are things the employer can do in that vein to better understand the situation. But what it's going to come down to is let's say it's 2 weeks, giving her 2 more weeks so she can return and perform the essential functions of the job with or without a reasonable accommodation is really what it comes down to. And whether an accommodation is reasonable or not hinges on whether or not it causes an undue burden or hardship to the employer.
Got it. That makes a lot of sense. Thank you, David. Just a follow-up question to that. What specifically should HR communicate to Agnes?
Well, there's a couple of ways to answer that, Catherine. I'm actually glad you touched on it. The first is, and please grab your writing stick, pen, pencil, chalk, Sharpie, whatever it is. When you communicate with an employee who's on leave, and you have a right to check in with them to see when they expect to return because you've got a business to run. Just be careful that you're writing the communication, not just to Agnes or Bob or Susan or Ted or whatever, but you're also writing this for a lawyer who might be representing that person and possibly for a judge or a jury. So be careful what you put in the communication. Second thing is, you know, your position's here for you. When you're able to return and do your job with or without a reasonable accommodation. Adding those words, with or without a reasonable accommodation, is what the Equal Employment Opportunity Commission expects of you. So Catherine, can you walk us through our second scenario, please?
Yes, absolutely. So this next disability-based request for a reasonable accommodation focuses on employee Jaden. And Jaden's scenario differs from Agnes's, but the steps to be taken by both the employer and the employee remain the same. Jaden is a deaf employee who's requested an ASL translator during his work meetings. He's made his disability known to his manager, and he's specifically asked for a translator as a reasonable accommodation. It's important to keep in mind that managers should not be expected to know exactly what ailments or conditions are considered to be a disability under the ADA. That responsibility lies with HR. However, management should be trained to go to HR with every single reasonable accommodation request. It is then HR's responsibility to know what is expected regarding the ADA, as well as state and local laws. So this whole scenario here with Jaden is actually based on a current case that's ongoing in the 11th Circuit. A deaf employee had requested and been granted an ASL translator for his work meetings. However, the translator was only provided to him on occasion, and his manager was not consistent about texting the employee recaps of the pre-shift safety meetings. There was also a breakdown in communication when his supervisor issued him disciplinary warnings for having missed work. The employee alleges that had he consistently been given an interpreter, he would have been able to properly explain that he believed his time off request had been approved and that the other days he missed were excusable because he had pneumonia. Now, the main issue in this case is whether the employer's failure to provide the employee with the accommodation that he requested prevented him from discussing and successfully resolving the disciplinary dispute. Now, keep in mind that an accommodation is reasonable and necessary under the ADA only if it enables the employee to perform the essential functions of the job without imposing an undue hardship on the business. Now that we've gone through two scenarios to highlight some important considerations, David, can you please give us a more solid introduction to the ADA?
Absolutely, Catherine. Thank you very much. Employees acquire rights under the ADA if the employee has a disability that is covered by the ADA, there is a record or a history of such an impairment, or if the employer regards the employee as disabled. A disability can be a physical or mental impairment that substantially limits one or more of life's major activities, such as caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. They also talk about major bodily functions, which include functions in the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. If an employee is protected, an employer cannot take adverse employment action against the employee that is motivated by the disability or being regarded as disabled. And another protection would be reasonable accommodations. Now, the employer just has to have 15 or more employees. Excuse me. The employer just needs to have 15 or more employers to be covered, and an employee has rights under the ADA at the time they interview or just apply for a job. They don't have to be hired. They don't have to be there for a year. Like the Family Medical Leave Act, you've got to be there working full time for at least 12 months. So that's a big difference also. Now, as briefly mentioned, an employee who is regarded as disabled may be protected under the ADA, even though the employee is not in fact disabled. However, another major difference is the regarded as employee would not be ordinarily entitled to a reasonable accommodation. Some of you may be thinking that's not fair. Well, if the person is not disabled, but they're regarded as disabled, then they don't need an accommodation to perform the essential functions of the job. That's why the difference. I wanted to touch on a small number of the medical conditions. Cancer is very interesting because for quite a long time, people with cancer were not protected under the ADA because cancer was not considered a disability. And the way that employees won those cases was because the employee was being regarded as disabled, and that's why they were denied promotions and sometimes terminated for the job. Yes, many people with cancer were fired because they had cancer. Another one was people with glasses were considered to be not disabled because you put glasses on and you could see fine. However, the people with glasses were not getting jobs that they could perform, such as pilots with glasses on. And the cases were hinged on the fact that the glasses enabled them to see, so they had no disability in the eyes of the court, not whether a person with glasses could actually fly a plane. More recently, there's been an increased focus on mental health, and that's where things like depression, post-traumatic stress disorder, and some of the impacts we've had over the last couple of years with the pandemic, has been under the microscope in the courts. And the last one I wanted to include on there is diabetes, because I actually am a diabetic, and it was interesting to follow the diabetic cases over the last couple of decades. Keep in mind one big difference between the mental health cases and the physical impairment cases, and that is that we oftentimes don't recognize a disability if someone's got depression or anxiety or post-traumatic stress disorder, we don't see that and understand it and appreciate it the same way we might if somebody, let's say, was in a wheelchair. So, Catherine, let's shift our focus now to reasonable accommodations.
An excellent plan.
All right, thank you. For purposes of this slide, we're going to talk about both accommodations under the ADA and Title VII. And let me preface the topic by stressing that the mere fact that a person is protected under the ADA does not mean that they have a job for as long as they want to work. The key is that the employee must be able to perform the essential functions of a job with or without that reasonable accommodation. The challenge is whether there is such an accommodation that an employer can offer so that a person can perform the essential functions of the job. This is typically addressed through the interactive process. An employee requests the accommodation and the parties go back and forth to see if they can agree on one. It's worth noting, you may want to write this down, that if it's a close call as to whether the employee is disabled, the best thing to do is to treat the employee as if the employee is disabled and assume the protections afforded to the employee under the law. Examples of accommodations can include adjusting hours, telecommuting, light duty, providing a leave of absence, and as mentioned earlier, extending a leave beyond 12 weeks, provided under the Family Medical Leave Act. However, the accommodations are not always reasonable and can create an undue hardship. For example, a grade school teacher wants to work remotely due to having a very bad back. She even wants to be able to teach remotely while lying down. That would pose an undue hardship. It would also not result in her being able to perform the essential functions of the job. The essential function being a classroom teacher. So that would be unreasonable for two reasons. Another is a dispatcher who wants to come in an hour and a half later every day because of certain health issues. Problem is, the drivers need to communicate right when her shift starts, and they will not be able to do it if the person's coming in 90 minutes late. So that would not be a reasonable accommodation. Again, it's going to help the employee meet the essential functions of the job and not be overly demanding. Now let's shift our attention to a brand new law, the Pregnant Workers Fairness Act. This applies to private sector employers with at least 15 employees, same as the ADA, as well as government employees. And this protects employees and applicants who have known limitations related to pregnancy, childbirth, or related medical conditions. What protections are provided? Covered employers are required to provide reasonable accommodations to workers with these known limitations. Same as the ADA, but here's where it's different. If an employee can go on leave, now they're eligible for leave, but the employee could get an accommodation that would be reasonable. You must give the reasonable accommodation. It's not enough to say, hey, we've got short-term disability, you can go on leave and you'll be fine. No, you have to give them the reasonable accommodation, which means you have to go into the interactive process, which we're going to talk about shortly. When does the law go into effect? June 27th, 2023. So before the law goes into effect, and you do have a window, it's an excellent time to ensure that your HR, your managers, your supervisors know how to address matters covered by these PWFA. This is also an opportunity for managers and supervisors to understand the rights that employees have and when it's necessary for management to meet with HR so that no mistakes are made. So Catherine, I didn't touch on religious accommodations enough. So can you hit that in the next slide, please?
Absolutely, David. But before I do, I had one last point that I wanted to make quickly on the PWFA. The PWFA is an important new law for many reasons, but largely because pregnancy is not considered to be a disability under the ADA. So pregnant workers are now afforded reasonable accommodations, which I think is quite important. And then lastly, on the PWFA, don't forget that this new law in no way impacts existing obligations under any state or local laws. So the PWFA is on a federal level, but if there are more protections that pregnant workers are entitled to under your state or local laws, make sure that your management and HR is properly trained on that as well.
Hey, Catherine, great catches.
Thank you. All right, so let's go ahead and shift gears from the ADA and disabilities over to religious accommodations. So religious requests for accommodations are guided by Title VII, and that's because religion's one of Title VII's protected classes. The scenario that we have outlined here is based off of another current federal court case. The plaintiff is an evangelical Christian who had worked for the United States Postal Service over a decade ago, or starting over a decade ago. And his religious belief is that Sundays should be a day of rest and worship, not work. Now, that religious belief was initially not a problem for him when he began his job, but it did become an issue after the Postal Service signed a contract to deliver Amazon packages. That then necessitated working on Sundays, and he was required to work on Sundays. And when he refused to do so, he was disciplined by his employer, and eventually he ended up quitting his job before he could be fired. So he filed suit in federal court in Pennsylvania and argued that the Postal Service had violated Title VII, which is Title VII of the Civil Rights Act of 1964. And Title VII requires an employer to reasonably accommodate an employee's religious beliefs and practices, as long as doing so does not create an undue hardship on the conduct of the employer's business. So the crux of the case, which is now before the Supreme Court, comes down to one question. What does it mean to be an undue hardship? The Supreme Court had answered this question back in 1977. That was in a case called TWA versus Hardison. And at that time, in 77, the Supreme Court said that an undue hardship is anything that imposes more than a trivial or minimal cost to the employer. And the plaintiff in this case now is asking the Supreme Court to overrule that 1977 decision. Keep in mind that this case has not yet been decided. A decision in the case is expected, hopefully before the end of the court's current term in June. So, within the next month or so. But in the interim, employers seeking to deny a religious accommodation as an undue hardship should make certain that the cost and the operational impact of granting their accommodations are well documented and not just speculative. David had touched upon this a few slides ago, but when in doubt, it is best to err on the side of caution, just as long as there's not an undue hardship that you can't. So now we're going to switch over to the interactive process. And both David and I had mentioned this in passing, but during this slide here, we're going to go into a little bit more depth. The interactive process is essentially the conversation that occurs between the employer and the employee regarding the employee's need for a reasonable accommodation. And it's the employer's responsibility to engage in this dialogue, and they should start the dialogue when they either know or reasonably should know that an accommodation is necessary in order for the employee to perform the essential functions of their job. the employee may request a specific accommodation, and then the employer needs to weigh the reasonableness of that option. For example, would a particular accommodation be unreasonably expensive for an employer to put into place? If so, the employer may indicate that that is not an option, but that there are other available accommodations. The discussion is a back and forth until the employee and employer can determine what steps can be taken to ensure that the employee can do their job with or without a reasonable accommodation. While these discussions are organic, it is important to be consistent when having this discussion, regardless of whether the employee belongs to any protected classes or not. One last point on this slide before we jump over to proper documentation is that the employer does have the right to request documentation from the employee's doctor, which states that the employee can perform the essential functions of the job with whatever that finalized accommodation is. All right, so properly documenting the interactive process can actually end up being exonerating documentation for companies if a disgruntled employee were to later bring a claim against the company for disability discrimination. The very first piece of evidence that a judge will ask for is documentation surrounding the interactive process. If there's no documentation, then the assumption is that the company did not engage in the interactive process at all. So the who in this slide is HR or management. The what is taking these notes contemporaneously as management is speaking with the employee to document the dialogue. That is the best practice so that the notes are accurate and fresh in the note taker's mind. The where is where to store the documents. Make sure that it's in a place that is accessible only to HR and to the managers who need to know about the employee's accommodation. That will help to maintain the employee's privacy. We've already discussed the why, which is to show that the interactive process actually took place, and that this documentation may end up being very helpful down the line should litigation ensue. And the last bullet point here is just a reminder to stay up to date when the interactive process continues. Remember that this is not a one-time discussion, and all of the back and forths should be documented. I mentioned that these discussions are organic and that no two interactive process conversations will be identical. But it is important to be consistent when having this discussion, regardless of whether the employee belongs to a protected class or not. David, would you mind elaborating on that last point, please?
Sure, Catherine. One of the challenges that we oftentimes see in companies, and this is especially so as they get larger, or it could be a company that's just got a lone wolf running it. But here's the problem. Two employees have a very similar medical condition, and they ask for a reasonable accommodation, and they perform the same job. One person gets the accommodation and the other one doesn't. Well, the one who doesn't get it is going to be the person who is going to go to a lawyer. And I'll use the name of a famous firm. And if you've been in prior webinars that I've presented at, you've heard the name before, Dewey, Cheatham, and Howe. And that employee is going to say, I was treated unfairly, here's why. And chances are the employee does belong to some form of a protected class. And in that event, now the company is exposed to litigation. So if you centralize the process and you're consistent with implementing the process, you can minimize this risk. Here's how you do it. You control who is involved in the interactive process. Certain people are permitted to engage in it on the company's side. I'm not talking about the employee, I'm talking about the company. Certain people can engage in the process, Certain people cannot. Certain people can be involved in the process to help determine whether the accommodation is or is not reasonable. But the ultimate decision is centralized. And by doing that, we know we've got data points and we know this is what we did for one person, this is what we're going to do for another person. So we are consistent in what we're doing. If we don't do it that way, then we're going to be making decisions that are going to expose the business to litigation down the road. And here's the why part, just to close the loop. We've talked a bit about Title VII. Title VII protects gender, race, religion, ethnicity, national origin. And then we've got age under the Age Discrimination and Employment Act. And here's the challenge. If one person gets the accommodation and another person doesn't, and that person has the ability to say, I didn't get it because of my race, because of my gender, because of my age, my ethnicity. There are a lot of reasons that person can argue. I'm not going to say that they're going to win, but there's a good chance they're going to make that argument. And then you'll have a decision. Do I settle a case? And so I don't have risk. I don't have to pay legal fees to litigate and the interference in my business issue for down the road. But being consistent is something that's very important to make work within your organization. Another thing that we should talk about, and that's the R word, and that's retaliation. And let's talk about how we can avoid the risk of retaliation. So retaliation occurs when a person engages in a protected activity. The employer is aware they engage in the protected activity. The employee suffers an adverse employment action, such as not getting an accommodation, termination from employment, other changes in the terms and conditions of their employment, and this close temporal proximity. Or put another way, but for having requested a reasonable accommodation, I would not have been fired. I would have not been demoted. So the employee arguing retaliation doesn't have to show that their age or their gender or their race or their disability was the motivating factor. They only have to show that they requested the accommodation. And here's the interesting part. They don't even have to be right. Maybe they were not entitled to that accommodation, but if they reasonably believed that it was something that legally they had a right to pursue, then they're protected from retaliation. They could lose everything else. They could win on just the fact that they reasonably believed it was something they're entitled to. So Catherine, I think it's time for the top 10 list. What do you say?
Certainly. All right, let's scooch over to that slide. There we go.
Okay. Hey, do you mind if I kick it off?
Oh, sure, go for it, please. Be my
Okay.
guest.
So why do we have error on the side of caution? You did hear Catherine mention that a few minutes ago. A couple of reasons. One, if it's a close call on whether a person is or is not covered under the ADA, it's best to treat them as if they're covered. Because if you treat them as though they're not covered, you have a couple of things. One, you're exposed to litigation. Two, this may not be something that other employees are going to be terribly happy with, and it could lead to things like unwanted turnover, engagement, morale issues. So err on the side of treating it as if they do have a disability. Now, as far as granting or not granting an accommodation, please remove managers from making decisions like that. Quick story, Dollar General. And if there's anybody from Dollar General on here, I apologize. But there was a type 1 diabetic who said, I need to have sugary substance with me when I'm working. Her manager said, no, you can't have that. That's not the look or feel. She gets a low blood sugar. She drinks an orange juice from their cooler. Cost $1.89. She paid for it, but she felt better. 2 weeks later, loss prevention and her manager fire her. She had a right to that reason to at least go through the interactive process regarding her request for that accommodation. They didn't go through it. $750,000 later, roughly, she won in court. That's a $750,000 mistake. So that's part of erring on the side of caution. Flip side is, you also don't want to be too generous with your accommodations, and you don't want to go down that road either. So the best thing to do as part of your erring on the side of caution is to have some internal meetings on talking about how you're going to treat accommodations going forward. Catherine, could you hit back on the PWFA, please?
Absolutely. If the slides would, there we are. All right. One last thing I wanted to mention, David, on the erring on the side of caution. And I think you did an excellent job of discussing that and illustrating that with the Dollar General example, which gets me every time. But you mentioned the ripple effect of denying an accommodation, and I think that's really impactful. You know, there's not only the effect on employee morale, but employers also need to consider the negative publicity as well if a lawsuit ends up getting brought, such as the Dollar General situation. You know, that was such a simple, avoidable issue that turned out to be extremely costly for the employer. So great job there, David. That was excellent. With respect to the PWFA, which David also did a lovely job of describing, the law does go into effect pretty soon. You know, it's less than a month away now, June 27th. So it's a very good idea to ensure that your organization's HR and management are aware of it, as well as the protections that it provides to pregnant workers. And remember that even though pregnancy itself is not considered a disability under the ADA, though some pregnancy-related impairments may be, known limitations related to pregnancy, childbirth, or related medical conditions are covered under the PWFA. And this is on the federal level, so it applies to all states. Just remember that state and local laws are still in effect. So if you've got a state law or a local law that adds additional protections or additional duties of the employer, it's really important to make sure that your managers are trained on that and that your HR is familiar with all of those duties. David, would you care to discuss the interactive process?
Sure, thank you. So we put this in because there have been times where complaints have been made that employees perceive that they approach the employer, they ask for a reasonable accommodation, and the process, if any, from the employer was a sham. Basically, they made a request and management said no. And there was never any back and forth. There was never any interactive. So to the extent possible, separate out the employee's performance. And let's suppose you've got a bad apple employee. And this was an employee that you had written up, you started writing the employee up, then they requested accommodation. And now you're at that point where you really don't want to give them any accommodation because you've had problems with them. Or you've got a manager who says, I can't do any kinds of accommodations, all hands on deck, all hands on deck, big deadlines over the next month. In those types of scenarios, it's important to take a step backwards and treat the interactive process like an exploration. What are they looking for? What can you do? What can you propose? What do they come back with? You can ask for the healthcare provider to confirm that they could do the essential functions of the job with this accommodation. Go through the process in good faith. And and I think in that sense, you're in much better shape. I apologize that I've been coughing. But Catherine, can you talk about documentation, please?
Sure. And I'm sorry that you've got that that bit of a cough going on. David, I've never actually heard of the interactive process um, being sort of an analogy for an explanation or an exploration, but that's really spot on. That's exactly what it is. It is this organic dialogue. It's a back and forth to explore together in good faith how the employee can continue to meet those essential functions of their job with or without an accommodation. So I really enjoyed your explanation there.
Thank you.
Of course. The importance of contemporaneous documentation. I did mention this one point earlier, but in my opinion, it's important enough to mention it a second time. It's really easy to think that you'll go back and write up your meeting notes at a later date, but it truly is best practice to just write your notes as soon as you have the interactive discussions. If you make a habit of doing that, it becomes second nature. And again, as David had explained, this is an exploration. It's an ongoing exploration together. So it's not just going to be a one-time request from the employee and a one-time approval or denial by the employer. It really is a back and forth. So as that back and forth continues, it's important to document each and every one of those discussions that you have. So whenever the employee or the employer reaches out to one another and when the other responds, it's important to just add a note to the file so that your file is as accurate as possible and as contemporaneous as possible. Similar to that, I believe, is actually the next point. David, did you want to delve into some of the privacy protection considerations for employees here?
Absolutely. And one important point regarding documentation, when you talk to people on your teams and, whether it's performance related, disability related accommodations, or whatever it is, here's one of the other major reasons why documentation at the time is so important. Think about this. What'd you have for dinner last night? Every hand would be up, you know the answer. What'd you have for dinner a week ago? Maybe half the hands are up and half are not. What'd you have for dinner 6 months ago? Nobody remembers, unless it's like a birthday or an anniversary or something. They don't remember. If you document when things happen, you get the story down. You wait a few weeks, few months, you don't have the story, or worse, someone makes a mistake and they put the wrong date on it. And then that lawyer at Dewey, Cheatham and Howe is going to try to catch you on that wrong date. So let me jump on the privacy topic. And here's the deal. An employee comes to you as a manager and says, I need an accommodation because something that they're going through, or maybe something that a member of their family has, whatever it is. It's not an occasion to gossip. It's so very important that and we're going to talk about coaching managers in a little bit, but it's so important that the managers understand what was shared by an employee is not going to become something that everyone in the business is talking about. Because once that happens, you've got an employee who may have a HIPAA claim, certainly is going to feel violated, certainly is going to be upset, and whatever is the reason for the accommodation may be scaring the bejeebies out of that employee. So we really don't want to be in a situation where we just poured salt on that wound. So Catherine, could you jump into the interplay between the different statutes?
Yeah, the last bit on the privacy protection that I wanted to note really quickly is that if that's the way it ends up playing out, it casts a really negative, chilling effect on other employees who might be wanting to and needing to request a reasonable accommodation. But if they think that the entire office is going to start gossiping upon their very private and protected information, they might be more hesitant to request that accommodation. All right, let's skip over here to number 6. The interplay of the FMLA and ADA regarding requests for extensions. So don't forget that even if an employee's leave under the FMLA has been exhausted, it's entirely possible, depending upon specific facts of the scenario, that that employee still might be entitled to an extension of leave as a form of a reasonable accommodation under the ADA. So once an employee has exhausted their leave under the FMLA, please don't make the assumption that they're not entitled to any more time, because they might be. David, we're starting to run out of time a little bit, but would you mind hitting retaliation quickly?
Sure. The concern with retaliation is simple, that I think the employee requesting leave should be told that it's okay to make a request. We're glad you made a request. We would never retaliate against somebody, and make the anti-retaliation posture for the business something that's part of your training of your managers.
Excellent. Then we've got consistently applying policies. This will really help to avoid disparate treatment claims being brought by disgruntled employees who might feel that their similarly situated colleague was granted a certain accommodation when they were not. So the take-home message on this point is simply try to be as fair and consistent as possible.
And on training managers, if a manager does not know how to respond to an employee who's got a question or a concern, and because of that, they fail to take the proper steps, the company is exposed. So taking the time, it's not complicated, but make sure your managers know what they can and cannot do when a request comes in.
Great point, David. And then the last point here is just with respect to communicating with an employee when they're on leave, please make them aware of the fact that they can return when they're able to perform the essential functions of their job with or without an accommodation. Those are the buzzwords there. As David mentioned, that's what the EEOC is going to be looking for. And by sharing that information with the employee, that may spur them to request a specific accommodation. And then the interactive process should begin. All right. And so with that, we are out of time, but we are so grateful that you chose to join us today. If you have any questions, whether it has to do with accommodations or the interactive process, or frankly, anything related to HR or employment law, David and I are both more than happy to hop on the phone with you. You can feel free to email us. We've included both of our direct lines on this contact page here, as well as both of our email addresses. So thank you very, very much.
Thank you again. Take good care.